As Aaron was saying, I'm an attorney. I work with game developers. I work with publishers. Our clients basically are dedicated to protecting their IP portfolios, and this talk is set up to kind of give you an idea of how to protect your assets as developers and as people who work with game audio. So how does sound really play a role in branding? Because that's kind of what we have to talk about whenever we start talking about trademarks and protecting your IP. What is your music trying to do in your game or in your product? Not just your music, but I mean your sound effects, your notification tones, your ambient music, all of these things, they play a particular role in your game or in your product, and a lot of that has to do with branding. It helps you identify that product. What is it that we're trying to do with music? What is it that we're trying to do with sound as far as developing an asset that not only creates a mood for your product, but also makes your product recognizable and gives it that distinctive quality? So by way of example, let's think of some music that we've heard and some songs that we know of that immediately bring to mind a particular brand or a particular image. Show of hands if who knows where this came. If you're not entirely sure, it's Lord of the Rings. This one might be a little easier. Everyone know this one? And so those are some musical scores. Those are kind of the epic sounds that we hear that still bring to mind particular products. They weren't necessarily developed specifically for the purpose of branding, but they have become a brand in and of themselves. There we go. Now, theme songs are really, really interesting for a number of reasons, and especially whenever we start talking about game audio. And another way that we use game audio, or another way that we use audio as far as branding, we make it something that people strive to achieve. We want them, it's something that you're actually looking forward to because, I did it. So those are the ways that we use sound, and there have been newer ways that we've been using sound, and it's become a new kind of territory in intellectual property law, and that's when we start coming into sound marks and sound logos. So by way of example, we're all familiar with this one, correct? Glad someone knew that. It took me forever to find that one. PlayStation. PS2. So those are the things that we're trying to protect. And the one thing that all of those samples had in common is that they, whether intentionally or unintentionally, they have come to represent that brand in some way. They have come to automatically cause us, the consumer, to associate that sound with that particular product. And as a result, the law has kind of changed to give people an opportunity to protect that as a trademark in commerce, instead of just relying solely on something like copyright protection, which in many cases may not be available. So there are different levels of protection. We obviously have your common law and state, your federal, and your international. And each of these play a role, especially when it comes to infringement, in how you want to protect your mark. So as far as the baseline, the one where you're not relying on statutes, the one that everybody comes to me and says, I want to sue this person, they're using my product. Well, have you registered your trademark? Have you registered your copyright? No. Okay, well, let's see what we can do. We do have some available courses of action through unfair competition law. An unfair competition law is basically any kind of law or an unfair competition is any kind of business practice that is deceitful, unlawful, and basically unfair, right? But not in the sense of what we expect as being unfair. It comes down to being so grossly unfair, so grossly wrong, or so grossly deceitful or fraudulent that it gives rise to legal action. Many states have regulated this by statute, but in many cases it's common law. And the benefit of things like common law is that it can be broader in scope, or it can be taken to different territories. Whenever we talk about trademark and patent, and even in some cases copyright, one of the biggest issues that we have is territory. Some things can only be enforced in a particular territory. With things like common law causes of action, like unfair competition, you may have the benefit of being able to seek relief in many different jurisdictions as a result, because many different jurisdictions will acknowledge this cause of action. The problem with that is obviously how each jurisdiction handles it is going to differ. So let's look at some federal regulation. We have what is a copyright? This is kind of I'm not going to read from my slides, but this is basically what qualifies as a copyright, and it's anything that you can do something with. It's probably the easiest way to put it. You can record it, you can reproduce it, you can change it, modify it. As long as you have some form of expression that reaches that threshold level of creativity, and you've been able to fix it in some way, whether it be digitally or in a physical copy, you have a copyright. And that copyright exists the moment that copy is made, or that product is fixed in some kind of medium that can be reproduced. Trademark protection is a little trickier. It doesn't trigger automatically. To a certain extent, trademark protection does trigger once you start using it in commerce, once you start using a mark in commerce, provided that your mark is not already in conflict with an existing mark or brand. The thing about trademark, however, and in the U.S. especially with copyright, registration is very important, and I always encourage my clients to register before it becomes a problem rather than after. It is way more cost effective to get this taken care of early in the game before it becomes an issue, instead of having people fighting you on the fact that you haven't registered your mark or you haven't registered your copyright, and therefore what they're doing doesn't constitute infringement. There's this broad misconception that it's only infringement if you've registered your IP. Not true, but it does give added incentive to register. And with trademark in particular, you are only entitled to Lanham Act protections if you have registered. The only other available remedies if you don't register is going to be unfair competition law or the common law that I mentioned earlier. So what are some of the benefits of copyright protection? And what we're looking at here is why would we want to register our copyright? Why would we want to rely on copyright law? Why do we want to develop our IP portfolio? Why do we want to make this an asset in some form? And some of the benefits for this is that obviously it exists immediately. You automatically have it. You always have a copyright, whether you formalize it or not. You are going to have a copyright the second you have your recording produced or your recording fixed in a tangible medium. If you register, it's cheap. It's like $35 right now, as far as if you register online. There's no excuse. if you don't have $35, you have way more problems going for you than protecting your IP portfolio. So we can assume that you guys have the means available to take that step. It's pretty straightforward. In most cases, you can do it yourself, especially sometimes with sound recordings. It can be tricky because you're often having to copyright two separate things. You're recording the sound recording itself, and you're recording the underlying composition if you're not recording, for example, a classical piece. And even if you're creating a classical piece, if you've made a new arrangement for it, then that's going to be an underlying composition, which is going to be subject to separate copyright protection. Some of the drawbacks: unlike copyright or unlike trademark, there is a limited term for copyright protection. You would never guess that if you looked at a company like Disney. Steamboat Willie, I think, was published in, I want to say, 1930, 1929. The copyright on that will not expire until approximately 2023. That's a long, long time for a copyright. So as far as, the duration being a drawback, it's not that big of a drawback. But if you're wanting to, maintain your brand for hundreds and hundreds of years, copyright may not be, the one and only thing you want to rely on for that. There are a lot of defenses, and one of the biggest problems, especially when we're talking about branding, is the concept of independent origin. And this concept comes about whenever two people who are on separate, in separate places with no access to one another's materials somehow create an identical work. Now, under the law, each of those works are subject to copyright protection, and neither of those works are considered infringing unless one of the parties can show that the other had access to their work. So access is mandatory in order to show infringement in copyright. Not necessarily the case for trademark. And so thinking about trademark protection and this concept of trademarking your sound or creating a sound mark. And I'll go into how that actually happens here in a bit. But some of the benefits of trademark protection: obviously, there is no term. For as long as you use it in commerce, you own that mark. After 5 years of registration, you can actually, there's a certificate of, it's not irrefutability, but that's more or less the idea behind it. And I'm missing the word in my brain right now, so I can't quite give it to you. But it does make your mark irrefutable or non-contestable. Here we go. So nobody can say, well, it's not a valid mark because it's not distinctive. Once it achieves incontestable status, then nobody can claim that it needs to acquire a secondary meaning, which is one of the standards needed in order to prove that a trademark is valid and is recognized. And what that means, as far as, just so you guys understand where I'm coming from, what secondary meaning means is, like, when we look at a word like Coke, it has acquired a level of distinctiveness and a level of secondary meaning. It automatically triggers, that word automatically triggers the brand to us, right? It automatically triggers that particular product, the red bottle with the white swirls and the cursive print. We all recognize that, and that's a big part of what secondary meaning is. It's that it's immediately recognizable to the consumer, and whenever we say apple, it's going to bring to mind. It may not bring to mind immediately the fruit. It may also bring to mind the computer company or the record label if you are a huge Beatles fan. There is no defense for independent origin. The standard of review, or the standard to determine infringement, is going to come down to likelihood of confusion. What that means is that if there are two marks that are extremely similar, the standard a court will use when determining whether the subsequent mark can be registered or is infringing is going to be whether or not consumers in the marketplace would be confused by that use. Now, the problem with that is that a lot of those protections are going to be limited to your industry. In some cases, even related industries may not be protected. So if somebody uses a mark similar to yours in a somewhat related industry, that can be a problem. And I kind of need to, I guess we're kind of short on time. Is that it? Okay. So I'll get through this as quickly as possible. What can you copyright and what can you trademark? You've got, you can get a good idea there. Sound recordings, pictorial works, audiovisual works, logos, things like that. Those can all be copyrighted. So what you'll find is that a lot of things are going to overlap. You're going to have a lot of things that are both subject to trademark protection and subject to copyright protection. Unfortunately, they are not mutually exclusive. These are the infringement standards, by the way, as I was mentioning before. We have substantial taking from the original work and access, which is required to avoid that original origin, independent origin defense. With trademark infringement, we have similarity and likelihood to cause consumer confusion. So, and as I was saying, these two can coexist, and what I do strongly advise most of my clients to do, and something that we are all very passionate about, is really creating an IP portfolio that is double wrapped, essentially. You have both your copyright registrations, your trademark registrations, and whenever we're talking about things like licensing, stuff like that, whenever we're talking about getting investors, things that you would not ordinarily think of whenever we're talking about copyrights and trademarks, things you don't want to think about whenever we're talking about copyrights and trademarks. Or actually, it should be reverse. Whenever you're thinking of investment and getting money, you don't really want to have to think about this stuff. So, but the truth is you need to, because investors are going to want to see clear title on everything that you put into your product, including your audio. In fact, in many cases, especially your audio. And as I said, these are not mutually exclusive. And one really good example of how these are not mutually exclusive that is a registered trademark. It is also subject to copyright protection. It was registered in 1932, and I believe they completed the requisite formalities so that it is getting the same kind of copyright treatment as Disney. So, what do you use when? Some of the issues that you need to keep in mind whenever you're talking about defending your IP and what you want to raise whenever you're sending out that cease and desist. If you have a copyright in, for example, an artistic work or logo that is sufficiently creative, and you want to use copyright in those instances where we're not talking about a competing product. We're talking about something that just directly rips your logo, directly rips your audio, or clones it. I mean, that's what we're going to be. That's when you're going to want to bring up the copyright issue. You want to use trademark if it's something that is competing but may not constitute copyright infringement. So it may be similar but not so similar as to constitute copying. Some courts may, there's this concept of preemption, which is one law taking precedence over another. That's something to keep in mind. Another major issue that we need to think about is international. If you are trying to assert your rights in a foreign territory, that's when picking your poison is going to be very important, because most countries that have entered into treaties with the U.S. will honor a U.S. registration for copyright. They will not honor a U.S. registration for trademark unless you've filed with the Madrid Protocol. So you need to be very, very careful about that, because you won't get the same level of protection for trademark and patents as you would for copyrights. And here I just have some general information on what you need to do to register a sound mark. As I said, this is kind of a new area of the law. Not a lot of countries actually allow people to register marks. I think Canada only recently started to allow it in 2009. So this is it's a new area. It's a fun area, and it allows you to register things like theme songs. So what does all this mean? Obviously, you want to make your IP portfolio as robust as possible, and to do that, you should register your marks, and you should also register your copyrights. Do what you can to formalize the IP that you own, because that makes it tangible, that makes it yours, and that makes it something that you can show to investors, show to buyers, that you own this. And whenever you have somebody infringing on it, you can go to that person and say, look, we have these levels of protection, and this is what we're going to use in our actions against you unless you cease and desist this infringing conduct. It is, as I said, picking your poison is going to be kind of important. Copyright protection may not exist whenever we're talking about certain things like audio logos, sound notifications, voiceovers. There was a case concerning duck calls for the amphibious vehicle tours all over Boston. We have them in Seattle too. But apparently there is a registered sound mark for the duck call that's used on those tours. Specifically the use of those duck calls on those tours. So not really worthy of copyright protection as far as creativity goes, but it does get the trademark okay. So if you have any questions, I think we're out of time, but if you guys want to grab me later, or if you want to follow us on Twitter or check out our website, by all means, we look forward to hearing from you, and hope everybody has a great Casual Connect.